The court is in session in cause number 329-208. The case is styled the state of Texas versus Eugene Marvin Odom. We have Mr. Eugene Marvin Odom, who is appearing via Zoom. Mr. Odom, is that your full name?
Yes, sir.
Mr. Odom, how are you doing?
Oh, I'm doing fine.
That's good. Now, Mr. Odom, you are here represented by your attorney, Mr. Marcus Wilkerson. Mr. Wilkerson, how are you doing?
I'm doing well, Judge. Thank you.
Okay, now, Mr. Wilkerson, do you waive a record in Mr. Odom's case?
Yes, Your Honor.
The state is represented by attorney Daniel Boyd. Mr. Boyd, how are you doing?
Doing well, Your Honor. Thank you for asking.
That's good. Now, Mr. Wilkerson, I have a motion that you filed that is titled Motion to Reduce Bond. Mr. Wilkerson, are you ready to go forward? Mr. Wilkerson, are you ready to, you must be on mute. I think you're on mute. Oh, wow. Yeah, we can't hear you, Mr. Wilkerson.
Oh, that's his attorney.
Okay, he's, I guess he's gonna try to get back on. Just hold on a minute. Mr. Wilkerson, can you hear me?
I can hear you now. I keep having problems.
Oh, okay. Are you ready to go forward?
Yes, Your Honor.
Okay, Mr. Wilkerson, you may go forward.
Okay, Judge, this is a bond hearing, and bond reduction hearing. We had a hearing in the criminal district court on bond reduction just on Monday, where some testimony was adduced both from Mr. Odom and his mother. At this time, I'd like to call Mr. Odom to the stand.
Okay, Mr. Odom, would you please raise your right hand?
Yes, sir.
Mr. Odom, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Okay, Mr. Odom, you may put your hand down. Mr. Wilkerson, you may go forward.
Okay, Mr. Odom, do you currently have any cash on hand?
No, sir.
Okay, do you own a vehicle?
No.
Do you own a home?
No, sir.
Did he go out?
Yes, cutting out for some reason.
Mr. Wilkerson, we can't hear you. Think you're having some technical difficulties?
Yeah, it's cutting out on this side.
I can't hear him at all. I think he's trying to change his location. Uh-oh.
Judge, can I ask you a question? I
No,
thought I was.
hold on, Mr. Odom, wait till your attorney comes.
Oh, okay.
You cannot be represented by an attorney. You can
Oh, okay.
make the statements that you want to your attorney.
Judge, can you hear me now?
Yes.
I'm so sorry about that. My audio cut out again. The last thing I'd asked Mr. Odom, and I didn't hear your response, was prior to becoming incarcerated, where were you residing?
With my mom.
Okay. Now, you're presently in on an injury to an elderly charge, correct?
Yes.
And there was testimony adduced on the record on Monday directly from the alleged victim in that case, correct?
Yes, sir.
And in the present case, you're charged with violation of a protective order, correct?
Yes, sir.
And that protective order also applied to that alleged victim, correct?
Right.
All right. Now, do you have, and in the testimony that was adduced on Monday, there was a denial from the alleged victim that the incident that formed the basis of the underlying charge ever occurred, correct?
Correct.
Okay. And there was some indication that that there may be that this case may that the case in that court may come to a resolution in the next 2 or 3 weeks, correct?
Yes, sir.
Okay. And now in the present case, you understand that that case may not dispose of the present case, correct?
Correct.
And so with regard to this case, are you asking the court to reduce your bond to an amount that would be sufficient to ensure your appearance in court for that charge?
Yes, sir. But I mean, I thought I was going, I mean, to be time served. I mean, I've already did 8 months on this protective order. That should be time served, right? I mean, that's what.
Mr. Odom, if we don't have a resolution to the case, in order for you to, once the other case is resolved,
Right.
if you can't have appeared in this court at the same time, and this case isn't resolved with that case,
Oh, okay.
would you like to be able to post bond and return to deal with this violation of protective order case?
Yes, sir. Yes.
Okay, and in order to do so, would you need a bond that would comport with your indigent status?
Yes, sir.
Okay, and do you think that between yourself and your family, that you would be able to raise the 10% or so of funds required for a bond of $2,500?
10% of that, yeah. Yes, sir.
And so are you asking this court to reduce your bond such that once that case is disposed of, if this case is not resolved at that time, you're able to post bond and then to resolve this matter?
Yes, sir.
Okay. Pass the witness, Judge.
Mr. Boyd,
Now, Mr. Odom, in that other felony offense, you're charged with the injury to an elderly or disabled person. Is that correct?
Yes.
And in this current case, you're alleged to have went back over there even after being arrested on that. Is that correct?
Well, so on this case, I mean, it's my mom, and she asked me to come back to the house because I take care of my dad. I mean, my dad's got a year and a half to, or they gave him a year and a half to live, but I'm the one who takes care of him. And I take care of all the house, around the house and everything for her. So, I mean, the reason I had the charges because my nephew is the one. I mean, he told my mom what.
on
Mr.
not
Odom,
just
I'm
this case, but all these cases here.
going to advise you to stop there.
Okay. Yeah, I mean,
No further questions.
it's my mother, sir. I mean,
Okay,
Yes,
now, go ahead on, Mr. Wilkerson. You may go forward.
I apologize, Judge. Mr. Odom, I believe you testified the underlying victim in the case was your alleged victim in the case was your mother, correct?
right.
In violation of protective order was your mother, correct?
Yes, sir.
But then your mother testified on Monday, correct?
Right.
And at that time, she was instructed to go to the DA's office the next day, correct?
I think, yes, sir.
Okay, and there's no longer a protective order in place, correct?
Not that I know of, sir. I mean,
Okay. And Mr. Odom, I'll remind you when you're answering questions to just answer the question asked, because you do have your Fifth Amendment right against self-incrimination. I'll pass the witness, Judge.
oh,
Okay, Mr. Boyd.
I have no questions, Your Honor.
Okay, now, Mr. Wilkerson. Now you testified that he lives with his mom, is that correct?
Yes, Your Honor.
So nobody said where she lives. I mean, where does she live?
she lives in Beaumont.
Okay, well,
Judge, do you need the exact address? We
no,
can-
I just needed to know whether or not she was a resident of this county. I
Yes,
just trying to
Your
see if he had any local ties, any family members, that lives in locally. That was the reason why I asked the question. Okay, so he lives with his mom and she lives in Beaumont, is that correct?
Yes,
Okay. Now, is he, Mr. Wilkerson, is he from Beaumont? Did you just move to Beaumont? How long has he been living?
so I lived here all my life.
Please remain quiet unless you're asked a direct question. No, Your Honor, he's been here all his life, or was born here, raised here. The father that he's referring to is actually a stepfather who raised him since the time that he was 2 years old, and is the only person he's ever known as his father. And so he has strong ties to this community and no ties really to any other community. Of course, the ties to this community are primarily in terms of his family, and his abode. And so, Judge, what we're asking, we're not asking, that the court just dispense with any necessity of a bond. However, we would ask for consideration. Essentially, what we're asking the court, Judge, is that Mr. Odom be able to post bond that would be sufficient to please the court, that he would return to deal with the underlying protective order charge once the felony charge is dealt with, if it's not dismissed in the course of dealing with that underlying charge, Judge.
Now, okay, now, I think you mentioned that he has a date for the felony, is that correct? Coming up pretty soon?
Judge, the indication was that we would return in approximately 3 weeks. I'm unsure if we have actually received
Okay.
a firm date on that.
Okay, so if 3 weeks, we say maybe sometime in January.
Yes, Your Honor, first part of January.
Okay, now, what about, let's see, if I do that. Now, this is, I haven't received any information about Mr. Odom's criminal history. Now, pursuant to Article 1.24 of the Texas Code of Criminal Procedure, all proceedings and trials in all courts shall be public. However, pursuant to Lilly versus State 365, Southwest 3rd 321, the right to a public trial is not absolute and may be outweighed by other competing rights or interests, such as interest in security, preventing disclosure of non-public information, or ensuring that a defendant receives a fair trial. I think criminal history may be public. Maybe it may not be public. But my question to you, Mr. Wilkerson, are you requesting that this portion of this hearing be closed with regards to prevent the disclosure of non-public information? And the information that I'm talking about is his criminal history.
Yes, Your Honor.
Okay, so the court finds that the party seeking the closure of the hearing have advanced an overriding interest that is likely to be prejudiced toward the defendant, and the closure is no broader than necessary to protect that interest, and the trial court have considered reasonable alternatives in closing the proceedings, and the court makes a finding that is adequate to support the closure. So at this time, this portion of the hearing will be